I don't need to be wrong. Got it. Well, I'm going to tell you. And so the window ourselves to store and we will on YouTube. Well, I told everyone we have in-person people, so wear your matching shirt professionally, and they all got the matching shirt. Okay, just waiting. So where's Gina and all? You got a marine tie on. That's all I think. Working, Christy?
Yeah.
I would never. Well, yeah,
You know, I've never used Teams, and it's like, man, this thing wrong.
I guess I'll reach out to you guys.
You guys,
Did everybody who's sitting out here get lunch? No, thank you. Y'all got you got wait food, or you're eating or already ate or something? Okay, I guess we'll go ahead and get started. I think we have some folks coming in. I think everybody here knows everybody, but just for the purposes of anybody new or any of your staff who are on, who perhaps have not met any of us in person. Obviously, I'm Judge Lyda, Bramblett. We also have Jason Ness, who's my court reporter. Hold on, I think we have something. Is that you, David? Seems like that might be on. We have Gina Arias, who is the court coordinator for Judge Bramblett, who many of you all probably know over the years. David Herrera, who's my court coordinator. Ana Sanchez, who is all my senior admin specialist. We have Jesse Carrillo.
Is that the latest?
Coordinator, who's with both of our courts. So
It is for training.
people are not. I'm going to ask everybody if you could please mute yourself. If you are on via Zoom, I think that's what's happening. And I think everybody probably knows Cesar Anchondo because he's been here the longest, right? And we'll have our other two bailiffs are coming in shortly as well. So I guess let's go ahead and get started. I do want to first let Judge Bramblett address everyone because he's our new addition to the court and just say a few words, profound words.
oh, well, thanks for the setup there, Judge. Good afternoon, everybody. I'm going on 2 months in, and it has been a pleasure. Everyone has been so understanding of my bumbling and stumbling. Let me tell you, this place is a great place to come to work, and I'm always happy to get here. And we want to keep it like that for you guys too. Okay, I mean, the stuff that we do, people don't come see us when life is going great. Okay, and they kind of latch on to us emotionally and otherwise, and we want to get them in and get them out as efficiently as possible and as whole as possible. So everyone has been very professional and very kind, and we appreciate it, and we hope to give you the same. Ms. Patino came in and was teasing me that this is my debutante ball where I'm coming out. And thank goodness I didn't have to wear a strapless gown. But at any rate, guys, we want to try to flesh out some rules and procedures, and these are trying to be user friendly. And one thing that I tell the staff, is like, man, I'm not married to any procedure. If you got a better way to do it, bring it to me, man. I don't know anything, so I can learn whatever we want to do. So keep in mind, we're not, we're hitting you with all these pages of stuff, and it's not to pick on you, honest to gosh, but especially in this court, the docket is so full that we're trying to find ways to streamline any steps. And I tell my staff, look, if there's something that I can do just as a matter of course while I'm doing a case, show me how to do it. I want to do it. The fewer steps that we have, the more likely it's liable to happen. If I don't have to pass something off 3 times over, I'm not always the most trustworthy, but if I'm doing it when I'm right there, you can be assured that I've done it. And I, it's like, well, I didn't see the message. I didn't know that you asked me to do that. So that's kind of what the purpose of these things that we're trying to do here. It's certainly not to pick on anybody, and certainly not to make your life any more miserable than it, or make it less miserable than it has to be. How's that?
And trust us when, so you all have the rules of practice. I know you all can read, so I'm not going to read it to you. We're really going to focus on sort of the pearls that not only are integral to us being able to move these cases. We don't have these policies and procedures because we like bureaucracy and administration. We have them because it streamlines the process. When you're sending a hearing request and you're like, oh my gosh, where's my hearing? Where's my hearing? Following these will help everybody get their hearings quicker. Not following them means everybody is now getting pushed back. So you'll kind of understand, you have no idea how much administration. I had no idea how much administration. I thought I just got to sit here and rule. There's a lot that goes on, particularly for these folks and the staff over here. So we're going to kind of go through things. I won't be able to notice here. We'll try and take questions at the end. If you happen to be here in person, just raise your hand and we can take it. But I think it's a little difficult for us to mute and unmute via Zoom to take those questions. And then at the end, we're going to just kind of do a Q&A, recommendations, advice, thoughts, ideas. I'm actually working on a judicial, what do you call it? Like not a questionnaire, but a feedback that you can all submit to our court anonymously. So you're not on the spot, where you can complain and tell us also what we're doing well. A survey, thank you, that's the word I'm looking for. Okay, so some of this is the same as when we all took the bench initially. Some of this is a little new. Some of it is we are re-emphasizing for the umpteenth time because it really does make everyone's life easier. You all know we each have our own Zoom ID for our own court. It never changes. It will not change. It even has a judge's chambers in there, so you can go in chambers with the court. Both these Zooms now have interpretation enabled. That now includes Judge Bramblett. Initially, I know Judge Pelletier did not. Just remind your clients of the entire thing. And you can go to the Zoom procedures to go into detail on that. One of the things we do see is when your client's in your office and you're on one device, that makes interpretation difficult. So remember, if you need interpretation, you need to have 2 devices in your office. Remind your client, this is a big pet peeve, have a staff member practice Zoom before the hearing with them so they understand, because we have an audio breakout room. We spend a lot of time with folks helping them with audio issues. If you have your secretary just practice a quick Zoom call with them, they check their connectivity, they know how to unmute. Interpretation have them explain everything beforehand. We have dropped, and it's going to be attached to these rules, which are on the EP County website. Who is it? Jesus Cifuentes has very nicely shared the whole interpretation in Spanish and in English for everybody that you can give your clients so they can walk themselves through it. It really, nobody wants to spend 15 minutes dealing with that at the beginning of the hearing, okay? Emails, do not use anyone's personal email for anything other than non-case related things, or if you have to share anything. You may get emails from me. Most of those are related to non-cases. We are not great at checking personal emails. We have a court email. They have a court email. We will not, if you go, I'm gonna email Gina because I've known her for 20 years and she, she's my friend. She will forward her email into the court's email and it will go back in line with the time received. So don't think any of your personal relationships that you have with any of our staff. And I mostly am really focusing on Gina because she's known everybody for so many years. Texting her is not going to prioritize you. All of that. Calling will not prioritize you unless it's an ex parte or some emergency. All hearings will solely be set from the emails. Now, this is where we're going to jump to the other part. That's why subject matter is so important. If you put the cause number and go see attached, it ends up just in the emails. If you put urgent habeas corpus, those will get prioritized.
Cause number, urgent
Thank you.
habeas corpus, cause number.
Because that's how we find all your EJs. We search and we know at 4 o'clock, we pull out the EJs. We know a TRO is coming, we pull them out. But the only way we can do that is by the inclusion of the cause number and subject matter and what is being included. That I would have to say is one of the most critical things that we have to talk about. And let's see, please utilize phones for emergencies or any other issue like that. I'm going to provide you, and if you all have a pen and paper right now or not, I'm going to give you all of the bailiff's cell phones. I think everyone pretty much already has Cesar's. Cesar's is 915-256-9019. And what I would perhaps suggest is that you attorneys shoot him a quick text and say, hey, this is Lisa. Hey, this is so-and-so. And that way he has it. So we've both been in private practice. You're our 0.1% going to get defaulted as an attorney in one court. It's not going to happen unless it's become chronic. You tell Cesar, you tell Christy, oh, here's Christy. You tell Orlando, I'm running late. I'm stuck with Judge Rodriguez. We will accommodate you. We all know what it was like to be out there. Or you'll be getting a call from the bailiff on your cell phone saying, where are you? So again, Cesar Anchondo is 915-256-9019. Christy Size, who you may not have completely all met, everybody, is 915-345-8563. She is also the bailiff for any in-person hearings with the Title 4D court. So if you were trying to get in with Judge Gonzalez or Judge Strathman and you have an in-person, texting her is probably the best bet because I know sometimes it can be hard to reach staff. Again, hers is 915-345-8563. Orlando Diaz, who I have no idea where he is, our bailiff. Oh, there he is behind me, is 915-491-1087. Again, 491-1087. Again, I urge everybody, shoot them all a text saying Lisa Davis here, Viana Patino here, and they'll have your cell phones as well. I think that's a great idea for everyone to have. All the referrals, Ana Sanchez handles it. If there's an issue, reach out to her. Jesse Carrion will be handling Judge Rivera's docket. We still will try and use her as much as possible now that we have someone who can actually coordinate full time. That really is helpful. Now into the nitty gritty stuff. I'm gonna start. Do not enable any fields in your orders or your forms or anything. I don't even fully know what goes into that. Sometimes I will get an order and it will say, sign here. It won't let me sign. It's not even like a DocuSign. The county does not provide us the highfalutin Adobe. So we can't edit. We can't do anything other than really type on top of things and sign. But if you enable certain fields, we can't even do that. So what it means is we can get it done. It's just an extra 2 or 3 steps for us to save it in a new format, which is an extra 2 steps. I could be signing your order with, if need be. So just make sure that is done. Or if we need to add additional language, that really helps us as well.
On your TROs and show cause, there's the new rules that they've adopted some new rules to Rule 29. Invite y'all to look at that. And in our packet, it's shown you, it's 21B. It's all now court proceedings, not hearings. And they've added in there that you have to notice of any court proceeding that the notice has to contain all information needed to participate in the proceeding, including the location of the proceeding or instructions for joining it electronically. And it has to include the court's designated contact information, which is the phone number to the court when you can't get in and stuff like that. And instructions for submitting evidence. If you're gonna, you got to give this notice out in every notice that you send out if you're going to do these. And we've included in the packet, I believe, yeah, on page 4 of your packet, what we think is complying with the rules. Okay. And I think we have an actual exhibit.
Yes,
notice.
in our, so the page 4 under notices, we include the language there, but if you also go to your Zoom proceedings on the last page, page 3, and this is just an example. I mean, we kind of just thought that this would be a good proposal. It'll say this matter is set for a Zoom hearing and it's got the information, it's got court information. And this would be an example that you could cut and paste into your notices, your TROs, etc. We will be adding these to our hearing forms as well, although they're pretty full as it is.
Yeah.
So just remember that this is the new rule. And our staff is trained on knowing what to look out for as well.
Right.
So that's just an example of suggested. I'm not saying that that's the gold standard.
See, like in our current TROs, you know, y'all leave the blank and then we try to fit in all the Zoom stuff because the forms are still from the good old bad old days. But at any rate, we're going to need to have the Rule 21B through D requirements here, and it will have you know where they submit their evidence and things like that. So new parts to the Rule 21 that always has getting beat up every legislative session. So if you have any questions or any problems with that, just let us know. But look at what we've provided in our packet here, so that you guys can understand. Also notice that the method of appearance has been a little bit changed as far as court proceedings and how we do it. It says that the physical presence, and I mean, unless it says otherwise, it's physical presence. And did you want to talk about?
No, I think we're still figuring this out. Like, I don't know if we need to make findings in order to continue by Zoom because of the new rules.
Right. Well, if one party
For good
doesn't,
cause.
yeah,
For good cause.
if one party objects, I mean, there's a good cause provision, and I invite you guys to look at that. But where we are is we're going to set it. We're going to assume that it's going to be Zoom, unless you tell us otherwise. Except for obviously the ones where you need somebody that might be going to jail or turning over a kid or something like that over 3 hours, as we provided in our packet here.
I'm going to jump on that. Do not assume you can appear virtually or that you can have a hybrid hearing. Do not assume that unless you have, we analogize it to the old days. If you had a client who lived in Utah and everybody was here in person, you would file a motion for your client to appear telephonically. So now, if you have a 3-hour hearing, but you're like, my client lives in California, can they appear via Zoom? Go ahead and file a motion for a party or a witness to appear via Zoom. That goes for witnesses too. Do not assume your witness can appear hybrid unless the court has approved it. Now, if you have a long hearing, you will have had a pretrial with us, so we can work those things out. But hybrid is not the ideal. We have decent sound finally in this courtroom, but it's still not the ideal. So you must show good cause, I guess, by statute. And make sure your subpoenas reflect the witnesses appearing in person. We've had some problems with that because people just have forgotten to update their subpoenas. So just everybody, now we're in this middle ground, just be really acutely aware of that and have your staff, most of your staff, I think, because they're the ones really doing this. Just remember on your hearing requests, include time and include interpreter. In Odyssey, there's a place David or Anna or Gina puts interpreter in there. And apparently the interpreters, the council of judges get a printout of that. So they start knowing in advance, and you know how we're the bottom of the barrel when it comes to interpreters and how low we are, especially if in person, because they have virtual interpreters and they have people here in person. So it's really important for us to know those in advance on our cases. Well,
Yeah, everybody may have a difference of opinion about, conferring with the child, and there's times when we have to, times when it's up to the court. But if you're going to ask me as the associate court to confer with the child, we don't want this kid to be interviewed any more than they have to, and philosophically, I think everybody can understand why that is. By the time a kid gets to us, in a lot of cases, they've been grilled by everybody in the family 10 times, maybe some cops, maybe the advocacy center. They've been interviewed to death. But it's kind of a delicate situation, and I used to tell my clients it's like, okay, you want the judge to talk to this kid to make the file here? It's like, you got 2 kids. Tell me which one you want to pick right now. Come on, hurry up. It's like, well, you can't do it. Why would you make your kid do it? So if you're gonna, you have the right to do it, and we're gonna do it. And I love talking to kids. Come on, but if you're gonna do it, we're gonna ask you to waive the de novo or just take it to Judge Ness, Garcia. Let's only interview this kid once.
right. It may be 18 months later and circumstances have changed and we need to interview again. But as a general rule, we don't want to have these kids come in and meet with judges more than they have to. We'll try and make accommodations if you think like, well, I don't know, we may need to do it again. I may go in with them and just sit there while he interviews. So at least we've done it once. Please tell your clients, contrary to what they think, neither one of us will ever ask a child, who do you want to live with?
That's correct.
That is not going to happen. That is a phenomenal amount of burden on a child. And when I do the opposite, what the child tells me, there's going to be a parent, I assure you, who's told them, you didn't tell the judge the right things, and they will be blowback. So you've all heard me say in court, I tell the parents, this is my decision. And I tell the kids that this is not on your shoulders. I'm the parent here. I make the decision. You may not make it. So I also tell every child, I'm ordering you not to talk about this with your mom and dad. And if they start asking you, what did you tell the judge? What did the judge say? Did you make sure you told them this? They get to say, the judge told me I'm not to talk about this. So we do that. So be very clear if you're just to give your clients reality checks. This is not the magic, whatever, so let's just be clear about that. On a similar thing, de novos on temporary orders, we might skip them and go straight for final, depending on the discretion of the court. That will particularly happen if I see your de novo has been reset 4 times. I'm gonna cut it and I'm gonna go straight to final. Because of this, we will never cancel a final because you have not heard your de novo on your temporary orders. We're gonna go straight to final. It's just not a good use of y'all's time or our time to do it that way. We are very strict on dismissing de novos. We will get you in as quickly as we can, but if we find they're just languishing, we are going to delock those. And that's really usually on our calendar, and particularly de novos on temporary orders. We very much like to look at transcripts, so always consider asking me to get a transcript. I'm happy to do that even at the county's cost so that we can have a transcript and really slim down the issues. So just so you know, okay, 14, this is, if you come away with anything today, this is the big pet peeve of everybody.
Well, here's the thing. Remember when I told you if there's something I can do that reduces one more step in the process, we're all going to be better for it if I can hit a button. I'm getting the orders, everything submitted to me, and it'll come to me and it'll say SK something, you know, your code for your scanner. And it's like, oh boy, great.
Do not reply at something.
Right. Well, and my little love letter in my email says, you know, make sure you have a cause number somewhere in your subject line. Well, I'm asking you, you know, if it's a PDF that's coming to me as a form, coming to us as a form for us to look at, sign, and work on. Please have the cause number first and the title of whatever it is. Temporary.
Sunshine divorce decree doesn't help us.
You know, and somebody here, I get just a SK something that's like, and I used to get on my staff, you know, it's like, look, man, if you're gonna scan something, put the title on it, you know. I'm now you've got me looking for SKB something 222. I mean, you don't even know what it is.
And let me sort of explain why. When they're moving orders into our folders to sign, or we're trying to sign orders, when we open that order and we electronically sign and it's not saved, we have to save it someplace else, go back, look at it again so that we end up physically renaming it, or it gets dropped in a file, and it's mostly Jesse and Christy who do a lot of the e-filing. They have to go in, open it up. That is like 4 or 5 extra steps where we could be signing orders for you or listening to hearings. It is a very simple thing for your staff to save that order, cause number, title, that's it. That's all it needs to be. Whatever you do internally is y'all's own business, but we are going to have like a 30-day grace period on some of this. And at some point we are going to get hard about it, and you're going to start kicking your emails back to you and asking you to resubmit it with the proper information. It is time that our staff and us spend that we could be doing much more important things. So we're not doing this just because we're being persnickety about it. We're doing it because it streamlines our work. So I already said this, just prepare your clients on interpretation. Uncontested.
You know, Judge Ness does Friday mornings, and people get moved into a breakout room, and Miss Sanchez is streamlining that process and stuff. I'm not set up for that yet. I mean, I'm still an uncontested whenever I can do it, but you got to have an order for me, man. I mean, and there will be times when, let's put it on the record, and man, we're never gonna turn away when parties are ready to agree to this. We're gonna accommodate you, but really, you know, when you have an uncontested, if we know you're coming, obviously we're gonna do that. Make sure that you have, you know, everything up and ready to go for us. Okay. And we'll try to find some designated days, but historically the way it was is, you know, if you're ready to go and you can check in with us, can you do it uncontested? Caesar, have we ever said no? Ever? We'll find the time. I mean, and if it's off the record, we'll find the time after time. I mean,
I think you did one at 12:10 for Carlos Quinones
Well,
and Ellie Nebraska.
yeah,
So that we
I
can
mean-
get it in.
but believe me, we want to be user friendly in that regard. Just make sure that you've got your stuff up, you know, there's, you know, I mean, we make pro se do this, an affidavit of proof of. Y'all can do that. I don't know if you can charge them any extra money, but I mean, if I've got an affidavit of proof of, I swear everything's still true and correct, and it checks it all off. You know, we're done.
Mr. Rubel and the Rosales do a lot of affidavits, so we get a lot of agreed final orders from them where.
We haven't seen any challenges on it, so. Okay. But, defaults, okay, you know, I hear defaults, it's like, okay, I'll do it, but man, this thing ain't gonna, you know, if it comes back, I'm gonna have to kick it, you know, it's just not gonna work, you know, if anybody complains about it. You know, you do have to have an affidavit that they're not service members, okay? You do need a last known address. You do need to have, you know, your proof of service. I mean, I can access it if it's been filed,
Well,
but
it should be filed because we need it on file for 10 days.
15 days. But I always included it as one of my exhibits too, but that's up to y'all. I'll, you know, and y'all have seen, and it might be annoying, I don't know. When I'm calling the case, I say the petition was filed on this day, they were served, I have it in my file on this day. There's no end, you know, I do this preliminary statement that might be annoying, you know, other than you ready to go. But I'm doing that to kind of lay the record for all of us. And make sure that you have everything and understand, you know, a default in a family law case, you still got to produce some evidence, okay? So,
And there's significant case law on that.
right, so you still need to, you know, hit your jurisdiction, tell us why, they're not paying child support, tell us why you think they ought to pay more than the minimum wage presumption if you have any evidence to do that. So just understand that in a default, it's still a proceeding where you got to produce some evidence and things like that, and we'll get you in, we'll get you out, but we got to hit all the check marks, okay?
Also letting the district clerk know that they need to issue the notice of default judgment. I just set aside an order way after it was entered on a motion for new trial, because we all know it's stayed, you get extended time because nobody sent this person notice of default judgment. So, I mean, that's the last icing on the cake that you really need to do. And I have not been great about really checking that service is on file for 10 days, but we're going to be bigger sticklers about it because it is really important thing. So very often people come in, it's like, are you sure we filed that? But you know, there's the service, and I'm like, it's not in here. Well, you can file it that day, but now we need to wait. These are just like the little sort of crossing your T's sort of thing. I think we mentioned it before, of enforcements and habeas require all parties and all attorneys to appear in person unless you're not seeking contempt or unless the parties and attorneys agree. You cannot, I believe there is a due process issue with just requiring a respondent and their attorney to appear without the petitioner and their attorney. You have to be here because you have a right to confront and they're quasi-criminal. So assume every enforcement is in person unless both attorneys have agreed otherwise, okay? I think you all know this already, 3 hours, anything over 3 hours are in person for parties, attorneys, and witnesses. We haven't been seeing a lot of people doing their, what it used to be called, like children's first or the equivalent at the end. Just remind your clients they do need to do it. There's so many online now, and I'm happy to let people do these online.
Right, as long as they're certified, I mean, they got to be
accredited or whatever.
And they'll have a little seal or something when you visit their website. We're not gonna kill you on that, but it's still required.
Mediations and amicuses, if anybody is not on our list, or you're just like, hey, I don't think I've ever gotten any that I really would like to, just send David an email. Both of us appoint, but we both use the same wheel so that we try and equalize. You can always request a specific amicus or a specific mediator. We don't have an issue with that. But just make sure that you have sent David your information. It'd be nice if you could include whether you speak Spanish and your rates on there so we can kind of know that information as well. Mediations as a general rule is required for any case over 3 hours, unless you come and tell me and you're like, there is no, we're 180 degrees. It's not going to happen. Back to you.
Okay. Well, I would welcome a place. Yeah, you know, I mean, any hearing that you're gonna have in the associate court that's 2 hours, we're gonna ask for a waiver on those. You know, I mean, we're trying to be user friendly and I know as a practitioner, I never like to waive any right that the client had ever, you know. But if you guys know how we operate, I mean, you know what's coming at us. So 2 hours, we'll give it to you, or we'll find it. It'll be a while, but we'll find it for you. But understand that we're going to ask for a waiver. If not, I mean, you need to go straight away to David and get it set with Judge Ness, Garcia. You know, I don't want it to be sitting on my docket. And it's like, the day of the hearing is like, well, where's your waiver? You know, y'all need to get that out. And I guess what I'll probably end up doing is I'll set us for a short, judges conference. If I'm going to give you a 2 hour, then we're going to have a real free trial, make you guys give me a witness list and all kinds of good stuff. But we need those waivers if you want those 2 hours, and then we'll set you for a pre-trial. Just make sure you got it. If we don't have it, and if you're not going to get it, why are we putting ourselves through this? Let's just go ahead and get it set with the judge, with mom here, with your mom, and we'll get it done. But
Yeah.
Again, that's how we think we got to do it.
Okay, we've already kind of talked about 26 and 4 pages.
Yeah.
So any hearing over 2 hours in the associate court waivers, they know what need to be.
Correct. And it will
Including temporary.
correct. And it will be
You
at,
guys are gonna have a hard time getting a 2 hour temporary order out. I mean, I'm just
You know,
telling you.
he's really going to try and continue as much as the policy that Judge Pelletier had, which is we're gonna, you know, in Dallas, they do 20-minute temporary orders. I don't really know how that's done. But if you get everything exchanged, we can streamline things, okay? So it'll be at Judge Bramblett's discretion as to whether or not he will cancel your final hearing if the waiver wasn't filed. So I'll leave that solely up to him, and he may look and see that it's been scheduled 20 times and make certain decisions. So just so you know, there are some questions here from Steve Fisher. Good morning. Why do we need a passcode? The judge decides who gets into court anyway. It's just an extra unnecessary step. Well, the Zooms have already been set up and published. It would require us to change our Zoom IDs in order to eliminate the passcode. It is also one extra security step that I believe is appropriate. And so that will continue. I have a question from what I imagine to be a litigant regarding another judge. I did indicate this was not an opportunity to talk about or vent about any of the other judges or to ask specific questions about your case. So I'm going to skip that question. Ms. Atkins is asking, affidavit for agreed divorce is. We were told you will not do you will not accept, I guess, an affidavit with kids involved. Did I misunderstand? You can do an affidavit for approve up for anything that's agreed on divorces.
Yes.
So that's yes, you may use them, Ms. Atkins. Okay. On the TOs, I guess the other thing is I know other courts have had policies where you can't piggyback TOs. We will let you piggyback. It doesn't make any sense for me to hear your TO and then hear yours on another day. The only things we won't piggyback really are probably enforcements. What we will do is, we're going to start doing what the associate court does. You'll see your your hearings will be at 9 or 9:01 or 9:02, and that lets you know whether you're a backup or what you are. We're going to start doing the same. So let's say you have a 9 o'clock TO and, Claudia comes in and says, I want my enforcement heard at the same time. We'll give you a 9:01. So we'll know, maybe we'll have time and we'll get to it, maybe we won't, but you'll have a good idea of that. But as a general rule, we won't piggyback unless they're really easy things.
Yeah,
Hard to-
I'm not sure if everybody understands what we're talking about. Is Viviana files, she gets a TRO, sets the temporary orders. Claudio answers and asks for non-temporary orders. And we've had those situations where it comes up, was like, well, mine's set, like, and I didn't get the notice long enough for them to have theirs, like, okay. And I guess, if we're gonna try to accommodate that, it's like, okay, everybody's getting temporary orders. Here we go. But if the law says that you could object to it, it's like, okay. So we'll hear the first one. We'll take it under advisement and then we'll get the other one set. The idea is to bring some stability to the situation, no matter who's asking for it. And so that's what we mean by piggybacking. You've asked for relief, they've asked for relief. You say, well, you didn't ask soon enough to have it in this hearing. All right, we're going to try to get one temporary order done. Okay.
If you're requesting support, spousal support or child support, this, you want to talk about that, the statute?
What am I supposed to be talking about?
Just remember, bring your last tax return
Oh.
or W-2 or last 3 pay stubs.
Okay, yeah, gosh, dang, man. It's like, man, if y'all want me to guess, I'll guess, but I'll probably guess wrong. It's like, we just did we did an hour hearing. I don't know if this guy works. I don't have a paycheck. I don't know what his work schedule is. I know he's a son of a gun, but I don't know any of the stuff that's gonna get. So, the rules, the rules of the required disclosures, which, here they are, they're on the books. That's for y'all to give each other, okay? What is it? 153.063 says, parties shall produce the last 2 years' tax returns and a year-to-date pay stub.
I think the problem, Judge, is that when you're, you get a TRO, and you have temporary orders here instead.
Right.
And you get them served. You don't get the disclosures right away.
No,
until they make an appearance.
Right, you got 30 days.
Yeah.
Right, and so much of what we're talking about today is really in when you have attorneys. But I can tell you that's 10 minutes. You don't have to have your client testify about what he does in his hours.
Yeah.
If you give me a pay stub,
A lot of
I can read math. I can do math. I can read math.
I
I can do it. Okay. But that prioritizes your time. Anything that streamlines a
Right.
hearing.
Well, and there is a way, I don't know how effective it's gonna be, but, here's your temporary restraining order, don't burn down the house, and you be here Wednesday at 10 o'clock and bring your pay stub.
Yeah.
And we are working on updating the current orders and findings of recs and a standing order to be utilized by all the family courts. Tomorrow, Judge Bramblett and I, Judge Rodriguez, Ms. Hayes and Ms. Moore have kindly agreed to come and we're going to sit down and go over them and then we'll come back for feedback. Yes, ma'am.
Proof of insurance would help too. Yeah.
Yeah. You're asking for a lot.
The statutes,
Just give it to the other.
right, well, when you file it, remember what that exhibit A is on that stupid form that we never did? When you leave.
But you're using the JEA, that's well.
Well, what,
Well,
you know, now that I'm doing it, I tell, people don't know how to get approved their insurance. So I tell my clients, go to HR and ask for, and HR will give them the cost of the family plan and the cost of the employee ownership. And in order to start doing that, it makes it so much easier.
I do know having checklists for your clients when they first hire you always helped me, and we always had that. We gave them immediately, start getting this stuff together, because someday we'll need it. Or I need it, even if it's agreed, so. Ex partes and attachments and habeas.
Yeah, you guys, I mean, extraordinary relief. I mean, when we get to, and we get plenty of them, and quite honestly, you guys, I can't imagine a case where you would want a temporary restraining order. I really can't. I mean, anytime you file a case, you know, you think, well, do I need a, if you're having to think about, do I need a temporary restraining order? You need a temporary restraining order. And besides that, that's how you get a setting for your temporary orders by statute. It makes us do it fast. But where the issue comes in is don't try to sneak in what is truly extraordinary relief that I really don't have the authority to give without extra proof. You know, if you're asking for extraordinary relief, please put that in the title. Temporary restraining order request for extraordinary relief. Add me some proof. Okay, and put it in bold in your body that you're doing this, because that's what the other side gets served with. And, you know, if it is truly extraordinary, you want to be able to point it out to everybody. So let's be very sensitive to that.
It's irreparable harm or injury. It is not anything less than that. And those magic words without the irreparable harm and injury underlying will not get you there. You will find I strike through a lot of ex partes. I'll get you a real quick setting because I know there's something exigent. And remember, imposing my ex who has no geographic restriction is leaving El Paso County is not a grounds for an ex parte order to impose a geographic restriction. Strickland is very clear that a change, that an imposition or a lifting of geographic restriction is subject to the same burden as a change of custody, which is emotional harm or, you know, that burden that when you change custody on TEOs. So don't think, oh crap, my clients just come to me and says their wife's leaving next week. If there is no geographic restriction in place, you can't get it through an ex parte. You cannot change custody through an ex parte. We still get a lot of really weird requests in ex parte. So go back and just look at the statute. There's some great cases there. I think a long time ago, I did a CLE on it. If we need to do it again, we can try and do that. But we are not going to, we are very strict about that statute. So don't promise your clients anything that you can't deliver to.
That's yeah, be careful. And I see these, you know, immediately attaching the child. You know, I mean, I doubt you know, it's going to have to be a really, really scary affidavit. I'm just not going to do it to a kid. Like I say, I'll try to give you as fast a hearing as we can.
Or habeas.
Or follow a habeas. And you can do a habeas when there's not a prior order if you can prove it. But man, that one's not going to happen in an ex parte situation usually, guys.
Yeah. Okay, and don't forget to notify the other attorney if there is one on there, or even a pro se who's filed an answer. Don't forget, you cannot do ex partes in the middle of a case without notifying. I think Mr. Dios, I have someone who's pro se who's asking for an ex parte, and I keep saying, you need to contact Mr. Dios, and I'll bring you all both in here to hear the ex parte, which you may end up hearing.
Sure.
You can't do it. Oh, we are? Okay. This all stuff is super quick. You all know it. We do scheduling and pretrial orders for all jury trials, termination, and bench trials over half a day. We tend to do them about 30 days before to make sure the mediations, everything have been complied with. My motion in limines tend to be the Friday before the Monday we choose a jury trial. So now if you want an earlier motion in limine, let us know, we'll do it sooner, but that's when we'll go over jury charges. That's when we'll go over any other last minute things. So that's how we kind of run things. On termination and adoptions, please submit your proposed orders at the pre-trial. All of our terminations and adoptions have pre-trials. We do this so you just suddenly don't show up on an adoption. Everybody's got their flowers and cakes and balloons, and you're like, so-and-so wasn't served. You know, I'm surprised. I would say close to 40% of a lot of the termination and adoptions, I have to tell them, you need to do this at the pre-trial. Well, you know, I mean, I know I'm not supposed to tell them, but they're not ready. And that's a horrible thing to have to delay when everyone's ready to go. So we ask for you to submit your proposed orders to make sure your pleadings actually conform with the grounds that you're using, because that happens a lot where people have these made up grounds that don't exist in the family code. I had someone saying they've abandoned the child. I was like, well, which ground is that supposed to be? You know, so I mean, and those are pretty serious cases. So I think you all know we have a different email for our exhibits. It's the 383 district court spelled out at gmail.com. We have the 383DC at EP County, which is for orders, hearing requests, anything the staff needs. You send it to the Gmail. I'm the only one who's going to see it. So you do not want to send any requests to the Gmail, only exhibits, because we hold on to them for Jason or, you know, the court reporters. The family court has one email for everything, and they move it around into different folders. Motion to withdraw and other orders like enforcements, just make sure you're sending separate orders. A lot of people send everything all together because I know ProDoc produces it together, I think. I cannot electronically sign an order that's still with its motion without printing it all out, then signing it, then filing it. On your motions to withdraw, please include your client's email. It allows us to input it and make sure we're sending out notice and the other attorney can send out notice so we don't lose contact. And again, the whole field things. This is a real big issue. DWAPs, final hearing DWAPs cannot be reset by agreement. I'll repeat for everybody. They cannot be reset by agreement. If your hearing says final hearing DWAP, somebody needs to show and explain why I'm not going to DWAP it. Y'all can reset your final hearing, but y'all didn't reset my DWAP because we set that DWAP. And it requires some sort of appearance and a showing of good cause why we really shouldn't DWAP it. And you will know that that has been that case that has languished for 2 years and has been reset and reset and reset and reset. We will DWAP them. We will. And one of the things we do require, we both do this, is if you're going to file a motion to reinstate, don't assume we will automatically reinstate it if we DWAPed it for a really good legitimate reason, unless you are submitting a proposed, especially on the EJ stuff, a proposed order with it. Then we'll reinstate it and we'll sign that final order.
Get a setting on your DWAP, I mean, on your motion to reinstate. The district clerk will send us notice, sort of, but you've got to get a setting on it.
One of the things that may be confusing for staff is because you're getting our notice and you will get a dismissal notice from the district clerk, that sometimes your staff just puts that in as DWAP. I have people come in a lot saying, oh, we just thought this was set for dismissal. And I'm like, no, I'm ready for your final hearing right now. And I've been nice about it, but we may get stricter because those are usually cases that are languishing that we do that on. Service. And I know Judge Pelletier did a great presentation on this, but
you know, I mean, please read the rules. What I'll say, when you submit a motion or I get people who will send me just the order for subservice, like, what?
give me a motion.
I mean, I need the motion that it goes with. It needs to comply with the stat, and I gotta have an affidavit of subscribes. I mean, I can't sign a subservice without it. Okay, y'all need to learn. Okay, you can print it one time. You publish one time for a divorce, but when there's kids, you got to do 4. There's OCA and the local paper. Okay, and you know, and the person who does a lot of ad litem work on these is sitting here nodding.
Well, the other thing is OCA and posting as well.
Well, you can't. Yeah.
I mean, you've got it, and
the clerk's not gonna know unless
You tell me.
you contact the clerk and you put it in your order. Don't use that variable phones order that's in ProDoc and TextDoc. I
Right,
mean, go in and put stuff in the order, and the court's gonna appoint an attorney at Lyda, so give
Give me and
them a line
to.
or a paragraph where they can do that.
Right, or you already do it, you know, when you're doing this, you already go figure out who owes you money to do your.
Because gone are the old days where you're all here for uncontested and you're like, hey, can you come do this uncontested? And you just grab somebody. So those are kind of different now because you'd have to exchange by email. So yeah, include that appointment. I think what the most important thing on the subservices, I will get an affidavit from the processor for saying, we went out 25 times, nobody answered. Well, I still need to know that, how do we know that that home is his home or her home?
Right,
So think about the fact that you need an affidavit from your client first that says something or whatever, or a private investigator who's identified it, because it's kind of a twofold step. So the multiple attempts by the processor is not just enough without some evidence that we think the respondent lives there.
right. I got one yesterday that was elegantly done. You know,
Can we give him a shout out?
Border Blue, it was excellently done until Border Blue did a skip trace report that's where they live. Then the process server did, you know, and sometimes you get these, the process server went at 131, 142, 153 the same day. It's like, come on, man.
Diligent effort.
But this one was elegantly done. I mean, that it's different days, different times, talked to people that was there. They did the skip trace. They filed the skip trace with the lady's social security number, driver's license, everything else filed in the file. It's like, please don't do that and redact that stuff if you can. I mean, I'll believe your skip trace. I don't need the social security number and driver's license as an exhibit.
Yeah, so that just review, and I think the OCA edition is a little, you know, adds something to the mix. Protective orders, anything standalone filed by the county attorney will continue to go to the 65th. If you have, they will be heard promptly, so we're not going to delay other proceedings like TOs and other things to wait. If there's another counter protective order filed by the other party, they get their standalone day. It's, you know, it's not, they don't cancel each other out by some sort of strange.
That's where we can't piggyback.
Right, definitely. You may end up with 2 protective orders, who knows? But if there's a simple divorce and you have a protective order, we also will be happy to send it to the 65th. Judge Gutierrez will accept any family law case if you want us to send it along with the protective order. Their docket is much lighter than ours, so we don't take any offense to that. Inventory and appraisals, they are required if you have a complex property case, or give us a proposal. There is nothing worse than spending 3 hours listening to a witness tell you how they want the, what was it, like the model cars or the TV or this. If you give us a proposal, and we have something to go along, and you've eliminated an hour's worth of testimony. Person goes, I swear that's what I think, everything's valued and this is what I want. Boom, we have it. I don't know if you all remember, but Judge Leverton, we were talking about this. Judge Leverton, if you gave him a proposal and the other party didn't, I guarantee you your proposal was not ruling over there.
Well, maybe not, but I guarantee you that's what I'm going to use to follow as my checklist. I mean, I might not, you know, I'll move some stuff in the car, but I'm going to be looking at the one that, you know, so, you know, I mean, if you want me to, I'm telling you, if you want me to guess, I'm going to guess wrong.
And it's handy. I look at this and says, oh, she says the house is worth 200,000. He says the house is worth 160. This is what my exhibit says. It's get you a ruling quick, and saves everybody time. That goes with all proposals. You know, philosophically, Judge Bramblett and I are a firm believer in co-parenting. We come from the idea that 2 involved parents who are able to act in their child's best interest should have as much as possible, equal parenting time or be able to co-parent. There are so many other circumstances, but coming from that, the more creative the possession and access you give us, we were just talking about it. If I know dad works every weekend out of town, I'm not going to give him first, third, and fifth. We're going to give them something else because we're going to maximize two involved parents in their life. So please do not expect the SPOs and the extended SPOs just as a rubber stamp. Give us something. We are happy to keep two parents involved with their child raising. So I think that's a great benefit to us, and it also helps your client work things out beforehand, right? Agreed resets, you can shoot us an email, you can call the bailiffs and let them know, hey, we agreed to reset this. So we know, we don't really care if y'all keep texting us as long as it's nothing substantive. I have a lot of attorneys who text me and said, hey, we came to an agreement on our 2 o'clock. It's helpful for us to know how to get our backups in. And we do have an open door policy. We want to hear what works. We want to hear what doesn't work. None of us are married to this. There's no ego connected to any of these rules. We want this process to work for the court and my staff and his staff so they don't get burned out. But we want it to work for you and your staff and your clients. So please, like I said, we'll be sending out a survey where you all can be brutally honest. We can take it. We'll probably do it in a couple of months to give you a little more time under his belt where you can say, you know what, we really find this difficult. I have a little journal that I keep, that I write things down in. And one of the things I'm always trying to do is remember what it was like to be there and to remember what it was like to be scrambling around. And, you know, all we ask is for courtesy. And I hope you will never find that you have been disrespected by our court or us. I really, really know what it was like to be yelled at when your client's sitting next to you and your client's like, what the hell are you doing? She's like,
I'll put you into a breakout room.
I mean, you know, when your client gets told off by me, it's a bad case. Because in fact, my staff was always telling me I'm too nice. And I've had attorneys tell me actually I'm too nice, but I really want people to be respected in court. So that is definitely our philosophy. Questions, advice, feedback,
Cookies.
cookies.
Great sound. Yeah. Are you doing a bill review?
Most of them have come to me. I am not doing what my predecessor did. We do not consolidate the bill of reviews into the prior
You
actions.
can't.
So we will not do that. So we will hear the bill of review, and depending on the outcome, if it's denied, case over. If it's granted, then what's happening is that original cause is going to be reopened, but it causes all sorts of mess to consolidate everything. So that is not, but I will hear it.
There's one focus on it,
We won't.
right?
Right.
And it now has a key number.
Correct.
And so when I'm getting a setting, I'm getting a setting under that key number.
Correct.
So when you hear it, and in this case, the conflict is, when you hear it, will the AG said.
Oh, that you actually remind me of something really, really good. The AG judge can hear. I have no issue with that. Here's another thing. If there is any OAG involvement, active pleading, intervention, anything, I have no issue with you all going to the Title IV court to hear those SAPSTA related matters. And you may have been with me during an OAG day where I'm like, I'm super backed up. Judge Strathman's going to take you and I'll send you down there. You can't say no if I'm asking her to do TOs. She can hear it even if you object, but I might do that with Judge Gonzalez and Judge Strathman.
So on the bill of review, do I get the setting review?
Yes.
You don't have to refer down.
Oh, I think you're saying, no, I think you can just go directly to Iris or Sylvia and get that setting. I mean, because then I guess you get a de novo, you get a second bite of the apple if someone's not happy with the outcome of that bill of review to me
Oh, that's good.
or to the referring court.
Thank you.
Yes, Ms. Diaz.
Kind of on that topic, so if the AG filed an original child support review order or plea, and then we file a subsequent divorce, most of the time before we would file an injunction, it would just come up. I had an issue this morning where we had temporary orders heard in Judge Strathman's court. We have a pending divorce in this court, but they're trying to set us for a final hearing on the child support issue in the AG.
So they want to bifurcate.
Like, right,
So what we have done, they cannot hear anything divorce related. So some of the things that we do is I'll send them down for temporary orders on the issue of SAPSA related issues. Sometimes, or if, I suppose if you wanted to, you could have that, but it doesn't make any sense sometimes because child support, spousal support, disposition of property may be wrapped up in some way. So I would just let them know it may just be an oversight on their matter, because if you've ever looked in Odyssey, there's like 1,500 tracks that they might not have noticed. But
and I think that AG was a little confused. Well, we set it for final here, even though you have a pending divorce. And so you may end up finalizing the child issue prior to finalizing the divorce, which I don't
You're not
think
supposed
it
to.
so you know what they think it is you know how many times you will have a final divorce where these people got their SAPSA order 7 years ago and now they're coming back for a divorce and they use that SAPSA order either as incorporating it or as an attachment or something like that. I think that might be the analogy the OAG is doing
Is this
there.
an original?
But there's a mandatory joint your rule. It can't,
I
it can't on the child support piece.
No, I understand.
Yes.
I don't know, and maybe the OAG just isn't aware of that. Now, as I said, for temporary orders or interim orders, I may send something down there if I really want you to get some possession access. And I know that Judge Strackman and I have had many discussions on her philosophy about she's not going to represent SPO, extended SPO, things like that. She will be creative with those issues as well.
Right, and I understand that, that was for fine, but I didn't understand why they wanted to set it for final, we have a pending. Or I think that both of them need to be.
Sometimes I don't know why
joined
the OAGs do things that they do. I cannot always explain those things. If there's an issue, go ahead and just email David.
in that. Okay.
Yeah, they need the numbers. They want the numbers. They want the disposition.
But just, I mean, mandatory joiner applies. So
Right.
Yeah.
Well, I figured that.
CC David or CC our court on an email saying, hey, we got a divorce. I think we need to set it all with upstairs. And I may sometimes keep it, sometimes I revoke. So even those we go up and down. Yes,
Good, in the default or waiver of the divorce. The husband wants his wife's name to be changed. What is your policy?
I can change, I can't make somebody change their name, just like I can't let, Miss Davis suddenly be called, Miss Wonderful. Only she gets to decide that. So it's her name.
Look, you guys have sat here for an hour. If y'all want to come get a
Come get more
cookie,
food, please.
come get some
Yeah.
water, stand up.
Because it was being done on me, it was being done.
So I guess a really good question would be, if it's a default and petitioner has requested a name change for the respondent.
The petitioner statutorily, well.
Well, it wouldn't matter. She still has to go change her name.
Well, it's the
What about it?
person whose name would change, who has the right to change the name under statute.
Right.
So the husband can't.
Right, you just line
And I'm
it up.
sorry, I've been forgetting about our little Zoom questions. Let me jump up early. Okay, Mr. Orlando Torres, what is advice if we've sent a request for a hearing and we haven't heard back in 2 weeks? Should we stay patient or resend the email? I'm gonna ask that question. We're human and there's always a very good chance something has slipped through the cracks. And they don't let us go into the emails anymore.
Well, actually, Judge Bramblett sometimes goes into the email searching for y'all's late filings of exhibits or something. So I could have goofed it up.
Because remember, it would say read or unread, and if someone accidentally clicked it and didn't leave it on unread, there's a chance it disappeared into some limbo.
Right, so
What should they do?
So the biggest reason is the case number wasn't included in the subject line, and that just kind of kicked it a little bit further down than the one that did have. the subject.
I think it's reasonable within 2 weeks to send another email or resend that email and say, perhaps this was an oversight. Please don't send emails to my staff that say, this is our second request for a hearing. I can tell you that might get you at the bottom. No, in a polite way, but we have some people who are.
But like David said, if you're gonna, if it's been 2 weeks and you hadn't heard back, you might want to look at the email that you sent and fix it. Put the call
Yeah, but
number,
sometimes-
request for setting,
Yeah,
and then,
yeah, sometimes all of this stuff is there and so.
I would absolutely agree.
So
Double check,
I think the suggestion,
absolutely.
I don't know if it's possible, but can you have a separate email for hearing requests?
We already have enough emails that we've over, and I can tell you, our email is only Jesse, Emma, and David are allowed in my email, and only Gina and Jesse and Seth are. And of course, the judges are allowed in that court, but I really try and stay out. So in our email, so you have a sense, they've created a 4-judge folder. And they drop things in there, exhibits, orders. So every day I go in there and that's how I sign all the orders that you submit. I try and stay out because they have so much of their internal system going and notes that they may have taken. We really try and stay out.
Oh, I can.
But if you haven't heard in 2 weeks, Mr. Torres, I think it's absolutely reasonable to send another email saying, just following up. We haven't received a hearing request. We won't be offended by that.
And if I may, Judge.
Yes.
You gotta understand. We get 100 emails a day. And. There's only Gina and myself. We try not to let Judge Bramblett go into the email.
And Jesse?
Well, and right now we have over 1,000.
We have
Active
1,300 cases active with.
Not just us, not just in the associate court. I mean, the
No, I think
district has another 1,000 or more. So it's just two of us, guys. It's just me and Gina. So.
And it's doing
I'm
things.
sorry that it's the thing because now Jesse's doing a great job helping us out with those emails, trying to get them your emails faster. But keep that in mind. It's just two of us. 3, not full time, but we get Jesse a couple of days and we have over 1,000 cases.
So
I
we
mean, how
share
many
Jesse.
We have in your staff. I guess. How many active cases we have right now?
Yeah, your back question either. Only my paralegals can.
Now you see the ratio that we have to build.
So Jesse will be Tuesdays and Thursdays assisting the associate courts and really helping them go through their emails. We now have a uniform system. All of our EJs are the same. 3 weeks after I render is EJ. So that way your staff automatically knows if you forgot, because I know I always forgot to write that down for Gina when I was going back to the office. It's always 3 weeks after rendition. And 4 o'clock by submission unless we're moving up a step. Second one will still be by submission. Third one, you're probably getting a mandatory EJ with Jesse. And then after that, you're starting to get DWAPs or with me. So just so you know, but just so you know, Jesse is going to be working with both of the courts and assisting them. So.
right, and now, if something comes up, if we've done the hearing and it's set for an EJ. And you know that you're fussing and fighting, there's something contested, let's get it. I mean, somebody order the transcript or look at whatever the notes were. If we got to fight about it, let's get it set.
Oh, I should tell you all, Bob Thomas's email did change when he transferred to another court, to Judge Baez's court. So if you've been sending record requests to him since January 1st, they have ended up in some weird limbo. Does anyone know offhand what it is? ro.thomas@ebcounty.com. So it's not his same email. Jason's did stay the same coming to my court. But just so you know, because a lot of people start complaining.
Jason, it's been kicked out.
I don't know, we might need to check with IT. I think we'll double check that, but I think he's kept the same email internally with us. If we have a motion, this is for Mr. Torres as well. If we have a motion for Capias for failure to pay support, we file a motion to revoke probation. Do we submit the same way along with an order, or do we require a hearing? I think if you're asking like in an enforcement, like in order to appear on a revocation, I'm not sure exactly if that's what you mean, but
No,
yes.
Judge, what I meant was if we already had the enforcement hearing, community supervision was ordered, there's a subsequent violation, we file a motion citing that violation, and we've already had the enforcement hearing and everything. Do we need to set that for a hearing for the order for Capias? Or can we just submit that motion for KPS?
I think
along
that-
with the order?
I think you'd have to do the order to appear, and then if they didn't appear on the motion to revoke, right?
Based on verification of the data.
Oh, you're talking about for the-
And evidence of non-compliance, the court can issue a KPS. And then there's a bond hearing,
And
and then you can set it for a hearing.
But that alias has to be with the motion to revoke.
Right.
File a motion to revoke, present the judge with the alias.
And it has to be pled for in the motion to revoke.
But yes, you would need to request, you would need to submit it with an order. But I don't need a hearing on the KPS, if that's what you're asking.
Okay, so we just submit an order to appear then, along with, let's say, the FINA to show that.
Either or, if you want them to appear because you feel we need to drag them into court and you need me to yell at them one more time, sure. Otherwise, you can just do the revocation with the KPS if it's verified, and then I don't need a hearing.
Okay, that sounds good. Thank you very much, Judge.
How early is the preference of the court to receive exhibits? As early as possible, but we won't ever exclude them if you're exchanging at the time of hearing or even during the hearing. It's kind of like the old days where it's almost simultaneous. But what it does help you do is talk to the other attorney and maybe agree on some exhibits, which helps everybody streamline things. Also, we're not always scrambling for things for my staff, so.
Right, we just need to know that they're being up and done, but we gotta know that they've been shared. Okay?
Yes.
You gotta share it with the other side before we are gonna take it up. Okay? I mean, you're right, good old days, you rip it out of your notebook,
For their clients walking in with that.
Right, so we're not gonna do some, if y'all didn't have discovery and the pre-trial that said all this stuff. We're not gonna exclude something just because, it's like, well, we don't have a magic cutoff. We don't,
It's not an exclusionary rule, it's really a best practices rule, is what I would call it. I will sort of artificially turn away and let you all screen share, and then let me know when I can look back. I've done that on some hearings when there's exhibits.
right,
Ms. Sprague did have an addition, I guess, what we were discussing. She indicated we've been doing temporary orders on the SAPSR portions, and then the final orders on SAPSR and divorce gets referred back to the recurring court. So that might have just been an oversight, I'm guessing, in this case. David has emailed everybody the rules of practice and the new notice of Zoom proceedings. I will go ahead and also drop it on the El Paso Family Bar Facebook page. Ms. Davis will have a copy, who is always a lot of people's go-to for getting things. I'll send it to our president, Mr. Monserrati, so you'll be able to get it there. It will also be on epcounty.com, but that takes a couple of days because the county has to upload it. IT does all of that. We'll keep some hard copies here if you need to pick them up. And you can always shoot us an email and we'll be happy to send it to you as well. This presentation will also be on our YouTube channel, which we don't really use for much except for these type of presentations. And we will share that YouTube to the family bar. So if you had staff members who couldn't be here or attorneys, you can have them look this over, because a lot of this is really important for your staff, even more than it is for the attorneys. Ms. Vios, you had stepped out. Ms. Sprague did indicate that divorce and that SAPSR should come up to me. So you could reach out to her if it was a mistake as well, I'm sure.
Ms. Sprague was a really good resource when you have issues with the AG. So.
She is.
Yeah. Judge, one thing, if people want to be added to the email list, we're trying to update it. So if they didn't receive information by email, they can shoot me an email so that I have it and I can get it to the powers that be so that
We can update
we
that
can
list.
update the email list and have a standard list.
So everybody, go ahead and make sure your email is updated with Ms. Davis and your staff's email. We'll add all your paralegals and staff into there if we need to give them updates. Facebook is where we post a lot of stuff. So for those of you who aren't socially on social media, just as an FYI, we do post a lot on Facebook, on our page.
I sent it to the office.
Anything further? Thank you all.
Guys, thanks for hanging in.
Thank you.
This-
Thanks.
Brett,